There is a drone program that is operating overseas and that has been, at least as we believe from government figures, to be extremely effective in dealing with some of the senior leadership of Al-Qaeda and other terrorist groups. So again, when we put this program together, I felt that we had to deal with this subject, and I knew that our moderator, John Radsan from William Mitchell College of Law, is one of the leading experts in this particular area. So this is a very controversial topic we're going to be dealing with, and John, over to you, sir.
Thank you, Scott. Thank you for inviting me. Thank you to our panelists, Hina, Bill, and Dave. I won't introduce myself or them. I think their credentials speak for themselves. I want to save as much time for a conversation about these very important issues as a part of this conference. If a panel goes well, you have to reward the panelists. If a panel does not go well, you blame the moderators. So I'm taking full responsibility. I lost one battle with our esteemed panelists. I wanted to jump in right now and start asking them very pointed questions about the drone program. And they said, put your federal prosecutor days aside. You're not going to be questioning us on direct examination. But our compromise was that each one of them would put out about 5 minutes of remarks, and I'm going to enforce the time very rigorously. And then we're going to have a conversation, the panelists among themselves, and I'll facilitate, and then we'll include you in the conversation. But I'd like to put down some markers so that we're speaking about the same references, same points. And this is a very large topic, and to carve out some areas that are important. So let's just take for granted that there is a drone program run by the CIA in Pakistan. I'm not confirming or denying that, but I think it's reasonable to infer from the media coverage that something is going on in Pakistan, and it is being conducted by the CIA, not by the Air Force. Let's also accept that there is drone activity in Yemen, or a drone program, and here we have two American agencies. The Air Force has a program, reportedly, and the CIA has a program. And in that country, we have an added level of complexity because according to the media, again, we have an American citizen that is on the hit list, the target list for both of those programs, for the Air Force program and the CIA program, Anwar al-Awlaki. So he's an American citizen born in New Mexico. He now resides, we believe, in Yemen. And there's a question of whether he is just a rabble-rouser or whether he's gone operational. Let's also put down some markers of continuity between the Bush administration and the Obama administration, because they have tried to justify the drone program, the killer drones. They have not been specific about a particular country or a particular place. And it's difficult to get into details, especially on the CIA program, when they neither confirm nor deny that they have a program. This is the double dance. And if I were making any recommendation, I think they should at least acknowledge that they have some role, and then they could get into the specifics of what they're doing. You even had a new director, Leon Panetta, with a bunch of reporters that said, well, this is the only game in town, talking about the drones and counterterrorism. Quickly, some of his staffers came up and said, well, the director was speaking hypothetically, and then everyone had this very strange look in the room. So what are some of the theories? I'll focus this on Pakistan. What are some of the legal theories about why we are killing some people in Pakistan? One is that there is a spillover from the conflict that involves American troops on the ground in Afghanistan. So there are some border strikes that have been reported, and that's one theory, is an extension of this conventional conflict. The second theory that we have heard, and this is from Harold Koh, former dean of the Yale Law School, State Department legal advisor, is that these are acts in self-defense. But like many lawyers, he argues in the alternative, and he also says that we are in a global conflict with Al-Qaeda. This probably came as a shock to some of the civil libertarians that supported Obama, and they hoped that Harold Koh would not continue this theory. That is a theory that was begun under the W. Bush administration, and it goes forward. So that's the legal framework. Those two countries, Pakistan, Yemen, and then these are three arguments that have been offered by the administration. Now, I've put out a few questions that I've discussed with our panelists. Some are legal and some are policy. And you, on the side of the moderator, you're going to take notes, and you'll give me signals, and you'll ask, how well have we done in addressing these questions? And if you think that these are unreasonable questions, then you need to tell me right now as we go through. And you'll watch the faces of the panelists and see whether they're willing. So question number one, I think, is Well, who can be targeted? Who can be targeted for killing? Question 2 that I'm proposing, and I see no objection, so we've made it easily to number 2, is does a U.S. citizen get more process if the citizen is being targeted? The al-Laki example. Are we going to provide additional protections as a matter of law when we're trying to target a U.S. citizen? Then the third question that I propose, and this would relate to self-defense or an invitation to come into an armed conflict, can the state invitation, the foreign state, Pakistan, Yemen, or some other country, can they ask for force to be used? Can they invite the use of force and keep it secret? And many of us believe that there is a dance that's going on in Pakistan, that Pakistan has approved the drone program at the highest levels. And we even believe that continuing debate and discussions are consistent with this, and that they say anytime you use the drones, we're going to protest vociferously for our domestic base. So for private purposes, we're going to say, that's fine, but whenever you strike with a drone in Pakistan, we're going to complain. And we're going to complain loudly so that our public believes us. As a matter of law, is this acceptable if we think we need an invitation of force? So I think we're 3 for 3 on that. Then the fourth question I propose, still a legal question, maybe we could blur it into a policy question, is does it make a difference what particular agency is using the force? Does it make a difference whether it's Air Force, CIA, or what about the role of contractors? And I recognize, well, this is not only a legal question, it could blur into a policy question. And then the last question, legal question, maybe a policy question that I hope is provocative, is can we imagine a situation where we're using killer drones, armed drones, on the Mexican border? We now have surveillance drones on both borders to monitor trends of illegal immigration, monitor other activities. Could the situation in Mexico get so bad, the drug situation, hits that come over there, that we could, consistent with the law, imagine or have armed drones on the Mexican border? Then the policy question, so that's policy questions, two-part, is you'll hear a lot of debate about legal categories, international human rights, international humanitarian law, self-defense. And it's a question I've had to the panelists. At the operational level, for the people that are running the program, do these legal paradigms really matter? Don't they all converge into a very practical rule of reason when we're talking about international terrorism? Isn't that the more important question of how certain are we? How good is the intelligence? And shouldn't we then be turning it over to operators rather than lawyers on this question? So that's my challenge to the importance of law in this area. That I believe that this might converge into one area. And then the last question is a very overarching question, is do you have any advice to the Obama administration? Our panelists can give legal advice or policy advice on the use of armed drones. And here we don't necessarily have to limit it to Pakistan, Yemen. We can talk about the use of drones in other countries where it's been considered. Somalia has been mentioned, and I've put out Mexico. So is everyone happy with these questions? I see people are writing them down. Then at the end of the session, we're going to decide how well did the moderator do in getting our esteemed panelists. You have 3 experts with different points of view on these questions. How well did the moderator do? 1, in enforcing time limits. 2, in getting them to help us answer some of these very important and difficult questions. Hina, thank you very much for being here.
Thank you, John, and Scott, for inviting me. It's been such a fascinating day and a half already, and I'm delighted to be able to contribute to the discussion. John laid out some of the overarching issues that go to the profound moral, ethical, policy, and legal implications of targeted drone killings. And there are a number of controversies, obviously, that I think our discussion is going to explore more deeply. But what I wanted to do is start out and say, given the difficulty of the issues, to posit 3 areas to my fellow panelists and to all of you that might be areas of agreement before we get into disagreement. And the first goes to wisdom as well as legality. And it is that no one has a greater interest, no state has a greater interest than the United States in articulating what constitutes the lawful and unlawful use of targeted drone killings. We have unleashed a awesome, used in the AWE, SOME, old-fashioned sense of the word, awesome tactic, and we haven't cabined, at least publicly, the circumstances under which it can be used. We will not have a monopoly over this tactic for much longer. Russia, Turkey, Israel, India, China, and Pakistan have or are seeking lethal drone technology. Iran has reportedly provided weaponized drones to Hezbollah, and the rules applied by the United States may be used against it or its allies tomorrow. I wonder if we can agree that it is in our national interest to be transparent about the legal standards for what constitutes the illegitimate and legitimate use of targeted killing.
Bill, you agree?
To an extent, but not entirely. I'm taking notes.
Taking notes. Dave, do you agree?
Fully.
Fully.
Well, then I would posit to Bill, if we can't agree, let's discuss what interest secrecy serves, and also discuss it in the context of some of the discussions yesterday in the panels about secrecy. Targeted drone killings aren't a secret, and even if they were, the secret's out. And so I would posit again that it is in our advantage to state that we are a nation of public laws and rules, not secret ones, especially when we're talking about matters that are quite literally matters of life and death. The second area in which I would seek some level of agreement is that the use of drones in the context of armed conflict is not unlawful per se, but that drones do raise significant issues about what it means for the application of the law of war and training when you have a weapon that one side can use without any risk to itself. Does that have implications? What implications does it have? There are complexities there, but in the interests of time and knowing that John is draconian in his limitations on time, I will move on to the third area, which is...
I'll give you some more time, but Bill, do you agree on the second point, that it's the use of drones is not unlawful per se?
I do agree.
Dave? We reached unanimity on one point.
In the context of armed conflict, we might have some disagreement if we start talking about it outside of the context of armed conflict. Let's preserve the option of disagreement. The third area is with respect to the conduct of targeted drone killings by the CIA versus the military. And some have said that CIA personnel who conduct targeted drone killings are committing war crimes because they, unlike the military, are unlawful combatants and unable to participate in hostilities. I would posit that the participation of the CIA in armed conflict is not per se unlawful, but that the CIA does not have immunity, as state armed forces do, for prosecution for commission of violations, for prosecution of well, let me just stop there because I'm about to get much more complicated. And also that to the extent that the CIA is engaged in conducting killings outside the context of armed conflict, then that is unlawful under both international law and domestic law. I'm going to stop there, and I look forward to the discussion on this.
Don't you want to know whether we agree with the point?
No, sometimes I don't ask questions when I...
Thanks very much to Duke and to Scott and to Charlie. These programs are always fabulous. I'm very honored to have been a part of several of them, and this one maybe is the best yet. Scott, you've really done a fabulous job with the program. I will talk about the CIA for just a few minutes, although I think our discussion should be far more broad-ranging than that. Let me say a few words that are directed specifically to the domestic law role of the CIA in these instances. It's certainly neither surprising nor unprecedented that the United States would, in appropriate circumstances, engage in targeted killing. We've done so at least since a border war with Mexican bandits in 1916. In a time of war or armed conflict, subjecting individual combatants to lethal force has been a permitted and lawful instrument of waging a war successfully. New elements of the policy, of course, have emerged in recent years in response to terrorism and to threats against the United States, and among those new elements, of course, is a significant role, apparently, for the CIA in controlling pilotless drones to carry out a targeted killing policy. Domestic legislation, the National Security Act of 1947 authorized the CIA to, quote, perform such other functions and duties related to intelligence affecting the national security of the United States as the President or National Security Council may direct. Such other functions and duties. Very broad grant of discretion to the CIA as directed by the President and the NSC. Although that original grant in 1947 did not likely contemplate targeted killing, the 47 Act was designed as dynamic authority to be shaped by practice and necessity over time. And by the 1970s, the practice came to include targeted killing. After the Church Committee learned of and disapproved of CIA assassination plots in the mid-70s, President Ford issued an executive order prohibiting CIA involvement in assassination, notably not restricting targeted killing. And Congress enacted intelligence oversight legislation that, as amended today, continues to require reporting to Congress by the President of significant anticipated intelligence activities. In the weeks after 9/11, President Bush signed an intelligence finding giving the CIA broad authority to pursue terrorism around the world. By statute, finding must accompany any covert operation approved by the President, including those that permit targeted killing. In the classified finding, the President reportedly delegated targeting and operational authority to senior civilian and military officials. The 2000 finding was apparently modified by President Bush again in 2006 to broaden the class of potential targets beyond bin Laden and his close circle, and also to extend the boundaries beyond Afghanistan. In explicitly permitting the targeting of an individual with lethal force, the finding also more narrowly focused the potential to inflict violence. Ever since the Hughes-Ryan Oversight Amendment of 1974, Congress has authorized the CIA covert operations if findings are prepared and therefore delivered to select members of Congress before the operation described, or in a so-called timely fashion thereafter. So long as the intelligence committees are kept fully and currently informed, that's the statutory language, the intelligence laws permit the President broad discretion to utilize the nation's intelligence agencies to carry out security operations, implicitly at least, including targeted killing. Such an operation would follow intelligence law as, quote, an operation in foreign countries other than activities intended solely for obtaining necessary intelligence, and thus would be conducted pursuant to statutory authority. To some, it seemed that the 2001 finding ran counter to that long-standing ban on political assassination in the executive order that originated with President Ford. The directive forbids political assassination, but does not define the term. Just what constitutes political assassination? What distinguishes lawful targeted killing from unlawful political assassination? The answer turns, at least in part, upon which legal framework applies. During wartime or armed conflict, whether authorized by Congress or fought defensively by the President on the basis of his authority, targeted killing of individual combatants is lawful, although killing by treacherous means through the use of deceit or trickery is not. Under the Constitution, the President may order targeted killing in defense of the United States in war. His authority as Commander-in-Chief to repel sudden attacks has traditionally had a real-time dimension as a sort of imminence requirement by analogy to the doctrine of self-defense at international law. Of course, we all know that a terrorist attack is usually over before it can be repelled in real time. And when the attack is a suicide attack, it's impracticable to strike back. In addition, the United States has learned to expect terrorists to pursue a course of continuing attacks against us. As such, over time, in domestic law, a doctrine of anticipatory self-defense custom has emerged that permits the president to use deadly force against a positively identified terrorist if he's exhausted other means of apprehending him. Congress surely has the legal authority to regulate that use of force, responding in part here to the suggestion that positive authority be declared and announced, and it has done so to a limited extent. In peacetime, I agree certainly with Hina's point, any extrajudicial killing by a government agent is lawful only if undertaken in self-defense or in defense of others. What rules apply when the United States is engaged in this more shadowy, non-traditional war on terrorism or a war or armed conflict against Al-Qaeda? In my view, I'll stop right here, the evolving customary law of anticipatory self-defense and intelligence legislation regulating the activities of the CIA supply adequate, albeit not very well articulated or understood legal authority.
Thank you, Bill. A note on the importance of the rule of law. I have no authority here. I have no sanctions on the panelists, but each of our first two panelists, they've come in under the 5 minutes. I said it yesterday, we met in the morning, and Dave, though, I remind Dave, our third panelist, he said to me, and I'm now outing a secret conversation. This is perhaps why I'm no longer at the Central Intelligence Agency. Dave said, make sure you limit each one of them 5 minutes. Be tough, 5 minutes. So Dave Glazier will now have 5 minutes to put his ideas out, then we'll jump into some of the questions that we have. Thank you for being here.
Now, having spent 21 years as a Navy surface warfare officer, I think the odds of me failing to take direction are actually lower than that of the other panelists. With only 4 minutes and 45 seconds to go, what I thought I would use my brief time to talk about was sort of my underlying assumptions. Because as we go through these questions that John will pose to us, you will get different answers from the three of us. And I think it may be helpful to sort of understand where we're coming from to put our answers in context. So let me explain very briefly my sort of fundamental underlying assumptions. First of all, I believe that faithful compliance with law, and in particular international law, serves the United States interests. It's become popular in the last few years to talk about something called lawfare, a general belief that law is something that our adversaries are using to our detriment in these conflicts. I totally reject that view as being inconsistent with United States history. From the revolution, the United States military has been at the forefront of insisting upon law of war compliance on our own part, and has been at the forefront of the development of the international law, because we recognized in conflicts that it served our interests to be perceived as being in the right and as being conducting our law wars in a legal and moral fashion. And certainly that is even more true today when counterterrorism is essentially a counterinsurgency, and success is ultimately dependent upon essentially winning the hearts and minds of the global public. And for those that are more realpolitik oriented, there has been real consequences from our actions. For example, the Guantanamo military commissions and the Guantanamo detention facility have demonstrably chilled international cooperation with us in terms of apprehending suspects, extraditing them, and turning over evidence to the United States. So I believe that there is a real clear practical national advantage to faithful compliance with the law. And so that's what I'm going to be arguing for in my answers to the questions. Second, I believe that the United States had a choice of paradigms with respect to dealing with terrorism. And I believe that the paradigm that we select should be based on a rational calculation of our national interests. So first and most obviously and famously today, we have the armed conflict paradigm available to us as a choice. That provides a number of sources of authority with it, which we are freely drawing upon, but it also provides some legal constraints which we seem not to be necessarily taking seriously. Now there's a second intermediate model, and that's the piracy model. It's talked about a lot with respect to Somalia and the situation there, but it's not often legally explained. In the piracy model, armed forces are essentially used as an adjunct to law enforcement. to go out and go after forces which are too powerful or too remote for traditional law enforcement forces to reach. But when those individuals are captured, they're treated under a law enforcement paradigm. So pirates have been brought back to the United States and put on trial in New York and in the Eastern District of Virginia because once they're captured, they are clearly in the law enforcement paradigm. There was never legal authority for summary execution of pirates. There was never legal authority to kill pirates who you could capture. That's not well understood. And then the third possible paradigm is the straight criminal law paradigm. Now, I think we can agree that after 9/11, it was clearly evident that there were real problems there. We were not going to send a force of U.S. Marshals to terrorist training camps in Afghanistan to round up the al-Qaeda leadership. So the criminal law paradigm in itself was clearly inadequate. But on the other hand, there are certainly still places where it has a role. Right? On the other hand, we're not likely to fly Predator drone strikes to take out an al-Qaeda safe house in Paris or Berlin. So it clearly still has to be part of the solution. But again, I believe that our policymakers should have a toolkit that includes all of these options and should select the model that best serves our national interest. But per my first assumption, I think that we need to employ these tools strictly in accordance with the law that governs them. Now, there's some debate about whether or not the conflict with al-Qaeda and the Taliban can formally be treated as an armed conflict or not. Now, to me, this is settled. This isn't just a matter of administration and policy. And there are two criteria that have to be met, it seems to me, for an armed conflict. First, you have to satisfy the international law criteria. And when the founders put in the Constitution that Congress had the authority to declare war, it seems to me that that was borrowing the language from international law as a clear signal that we would have to satisfy the requirements posed by that corpus juris. And then we have the domestic law requirement, which is congressional authorization. To my thinking, both of these criteria have been met. NATO, which is a grouping of leading Western democracies, found the 9/11 attack to be the first armed attack on a member state in the half-century history of the alliance. The UN Security Council passed 2 resolutions which both referred to the United States' right to self-defense. So from my perspective, the international law threshold is satisfied. To my thinking also, the authorization for the use of military force passed by Congress just a week after 9/11 satisfies the domestic constitutional threshold requiring congressional authorization. And I think that the Supreme Court has recognized this in decisions like Hamdi. So to my thinking, this isn't just a matter of executive policy. We have, in fact, the participation of all 3 branches of the United States government in finding that we're in a legitimate armed conflict. That being said, the authorization for the use of military force essentially constrains who we're in an armed conflict with, because Congress has authorized an armed conflict against the perpetrators of 9/11 and those that aided or harbored them. And I think there are issues that will come out in further discussion about some of the folks that we are proposing to use military force or drone strikes against as potentially being outside the scope of this authorization.
Thank you, Dave. Let's use your reference to the Hamdi case as a way to dig into one of these questions. Bill is the editor of one of the leading case books, the leading case book on national security law. They put these constitutional law cases out for our benefit after 9/11. So the Hamdi case, if you recall, was a 2-part question. Does the president have the authority to designate a U.S. citizen who was captured in Afghanistan as an enemy combatant? Was the first question. And if so, what sort of process do we have to give this person? And you recall O'Connor wrote the plurality opinion. And on the first part, the authority question, she viewed it as a war question. She relied on the authorization of use of military force that Dave referred to. He said the president has this power. It's a fundamental incident to take people from the battlefield. So that's war talk. In the second part of the opinion, however, when she went to the process that's necessary to make sure that this U.S. citizen is indeed an enemy combatant or falls within that category, it was Matthews versus Eldridge, due process talk, Social Security disability case that she's using as her guidepost. What appeals to me in that opinion is this recognition that counterterrorism does not neatly fall within any of the paradigms that we have. That it's not fully war, but it's not fully law enforcement. It's not fully due process. But I prefer O'Connor because I think she leans toward war. So using that framework, now we're thinking about targeting. We have put al-Laki, a U.S. citizen, on the hit list in Yemen. Let's accept that there must be some war justification to this, that we're in a global conflict with Al-Qaeda, if we accept that benchmark or self-defense, do we need to give that person more process? More process because the person is a U.S. citizen, or even more transparency. So I'll throw that out. So Dave, you went last. We'll let you go first on this question.
Okay. Well, this will sound radical as far as making me sound now like some sort of radical rightist, I suppose, but I don't think so. I look back at the Kieran decision in World War II, in which one of the 8 Nazi saboteurs asserted U.S. citizenship, and the court basically said it doesn't matter. What matters in armed conflict is affiliation with the enemy. And so if you as a U.S. citizen choose to join the enemy in an armed conflict, you'll be treated just the same as any other enemy. There was a Ninth Circuit decision, Torito, who was an American who had joined the Italian force, was captured and brought to the United States and held in a prisoner of war camp, and he tried to assert that he was entitled to special treatment because of the American citizenship, and the Ninth Circuit said no, you get the same rights as everybody else. I think what raised the issue in Hamdi is the fact that the factual situation in using military force against terrorists, essentially, is complicated by the fact that they don't have uniforms, they don't have identification cards. Now, it seems to me that the law of armed conflict actually deals with that situation. It's explicitly addressed in the Third Geneva Convention, which calls for a tribunal to be used to decide the legality of detention, essentially in cases of doubt. The problem was that the United States, it seems to me, after 2001, was drawing authority from the law of armed conflict without making an effort to comply fully with it.
So, but you're saying it's easier to whack somebody than to detain somebody under American law.
Yes.
Well, what I'm trying to suggest is that the process used to make the decisions is not dependent upon citizenship, and that I think that this peculiar aspect of the Hamdi decision is explained by the fact that the United States was not at the time providing any process to any detainee. And so the court took particular offense when an American citizen on U.S. soil was the victim of this. But I think, and the court was limiting the holding in that case, I think, to the question presented. Now, the Bush administration clearly recognized that, right? Because they immediately, or almost immediately, implemented the Combatant Status Review Tribunal for Guantanamo. Now, there was no need to do that based on the decisions that they were presented, because Hamdi only applied specifically to an American citizen in the United States. So I think the United States recognized at that point that its failure to comply with the screening requirements of the law of armed conflict was biting it in the backside, and the fact that the corresponding Rasool decision, decided at the same time, said that there would be habeas review for Guantanamo, said, oh my God, we're gonna, get into this issue again, so let's just recognize the handwriting on the wall. But I think the whole thing would have been headed off if the U.S. had simply complied with the law of war rules and had a screening process for detainees that had credibility up front. But I think that process could have been and should have been the same for all detainees, regardless of nationality.
Bill?
I think detention is different than targeted killing, and so I don't think that Kieran or Hamdi are persuasive here, and I think the answer is yes. I think we should do more for a U.S. citizen than we do for someone else in the targeting, and I think it
As a matter of law or policy?
matter of law and policy. The problem, of course, is that we won't be able to find out what the law is. But I think the government has an obligation to take greater care in linking the potential target to the activities that he's alleged to be connected to, and to have a great deal of intelligence on location and isolation of the target from other civilians and the like, kind of care that we take generally, but with, I think, greater rigor, perhaps more layers of review in the event of targeting a U.S. citizen, and that may be required by the due process clause, I'm not sure.
Hina?
I think what the court said in Hamdi is that the United States is in a non-international armed conflict in Afghanistan with Al-Qaeda and with the Taliban. It did not answer the question of whether or not that armed conflict exists in other parts of the world. The court could have taken on that question in Meridian, and China chose not to do so. So I'm going to start out by disagreeing with you, John, and with the premise of your question that, in fact, the armed conflict paradigm exists in Yemen.
You're disagreeing with the administration, too.
Well, I think that the administration has not made the case publicly that it is in an armed conflict in Yemen. It has said that it has alternative bases for being able to target a U.S. citizen, assuming that you count legal pleading arguments as an admission there. And the alternative legal bases are the laws of war, laws of self-defense, or the concepts of co-belligerency. Now, the U.S. has expressed in saying that a menu of options, and that's fair. States have menus of options that they can use in the context of counterterrorism. That's something that we all agree in, that it's not an either-or choice, law of war or law enforcement authority. But the issue here is that we don't know, and it hasn't been articulated, whether in fact law of war, armed conflict authority is what's being asserted. And I throw this out because it is not true that every time a terrorist group seeks to do us harm or asserts that it wants to harm us, that it arises to the level of an armed conflict. Under the laws of war, you look to objective criteria and facts on the ground, which include the intensity and duration of attacks. And if attacks are isolated, then they have to be more intense and have a higher level of organization. The question we don't have an answer to here, for example, when we're talking specifically about Yemen, is, does Al-Qaeda in the Arabian Peninsula, ACAP, arise to the level of a party against which the United States is in armed conflict? And has that justification been made? I think the answer to the first is a difficult question. The second, I don't think that justification has been made. So I would contest that the premise that we are in fact in an armed conflict in Yemen. And as John and the other panelists know, certainly the ACLU brought a lawsuit that sought to gain clarity on that. We unfortunately did not get clarity on that, but we argued that in the context of a US citizen, outside the context of the case for an armed conflict paradigm existing and having been made, then yes, that citizen is entitled to the full protections of the Fourth and Fifth Amendment, which include notice of what conduct would constitute the sort of violation that would submit the citizen to killing without charge or trial. And also that under the Fourth and Fifth Amendment, the only circumstances under which a killing may be legal, and we asked the court to rule on it, which it declined to do, is if the killing, if the threat presented is specific, concrete, imminent, and if there are no other reasonable alternatives necessary.
Let me be more precise about an assumption. I think we've gotten answers on one questions. We don't have unanimity, but you'll mull over and then you'll come to your own conclusions. Let's assume that we cannot capture Zawahiri. I think that's a fair assumption. We don't even know where he is. He's the number 2 person in Al-Qaeda. If we are in a conflict, I'm going to insist that we assume that we can kill Zawahiri. Let's think, is there a legal category that leads to that assumption? Reasonably, yes. Now, with that assumption, does it make a difference? Let's assume the intelligence is good. Let's assume we cannot capture him. Does it make a difference who pulls the trigger? CIA, Air Force, or a contractor? Dave.
You want me to go first again? Yes.
Unless Bill wants to go first.
This is one of the positions where I know I differ strongly from John and perhaps from Bill. So
I don't have a position.
I'm honored to be able to. What did you do in your prior life? Now, as Hina said, the law of armed. This really raises the fundamental issue of who can participate in an armed conflict. Now, it is true that the law of armed conflict, I believe, and I think virtually all law of war scholars agree, does not criminalize the direct participation in hostilities by a civilian. But we need to be very clear that it does not authorize it either. Now, the law of armed conflict, and here particularly because I agree that the application of the Geneva Conventions, which seems to be the law that everybody knows about, to this conflict is problematic. Common Article 2 says that the Geneva Conventions apply to an armed conflict between two or more state parties. The adversary in this conflict, at least because we're focusing on al-Qaeda, is not a state party. And so one thing I think the Bush administration got right was that the full text of the Geneva Conventions aren't going to apply. There's been a lot made about Common Article 3 by a holding by the Supreme Court in the Hamdan decision, but I think they got it wrong. Common Article 3 clearly says it applies to an armed conflict conducted within the territory of one state party. This is not an armed conflict conducted within the territory of one state party, so this is not a Common Article 3 armed conflict either. This is either a transnational armed conflict or it is an international armed conflict under customary international law. It is not an armed conflict addressed by international humanitarian law, meaning the Geneva Conventions. So we really have to go back to the 1899/1907 Hague Conventions, which provide essentially the current customary international law rules. And those conventions talk specifically only about the legality of armed forces participating in an armed conflict. They require that you have command responsibility. Okay? You have to be under an actual military chain of command with superiors who are legally responsible for their subordinates. And as the Yamashita case at the end of World War II pointed out, that means being answerable with your life for the conduct of your subordinates and the ability to punish, even to put to death after trial, your subordinates for violation of the law of war. That is not present in the CIA. Second, it requires a fixed distinctive emblem. That is not present with the CIA and CIA contractors. It requires carrying arms openly. Well, I would argue that flying a drone is actually carrying arms openly, and it requires following the law of armed conflict. There's no inherent reason why CIA personnel can't be trained to follow the law of armed conflict. We don't know if they are or are not, but that's not an inherent barrier.
Could they wear a uniform? Could the drone operator, if there's a
Well,
drone operator,
I don't think if you're a
wear-
civilian, then you can't play, you don't have a legal right to wear a uniform. I guess,
Blue polo shirts?
blue polo shirts, yeah. I don't think that satisfies the requirement.
Make sure it's
here's the
blue.
so the issue
not
though
the,
is
not the Carolina blue that Scott Silliman, our great
Okay.
founder and director, continues to wear, even though he teaches at Duke University.
So the question becomes, though, what are the legal consequences of this? Now, most law of war scholars, myself included, believe that because the law of armed conflict does not criminalize the direct participation, what it merely does is fail to immunize you. Because every country in the world has criminal laws that prescribe the use of violence. If you kill or injure someone, if you destroy property, you commit an ordinary domestic crime in every country in the world. But yet that's what military personnel are called upon by their governments to do for a living. And so what the law of war does is it says that we have to take the combatant out of the civilian legal system and standards and put them into a system in which their conduct is judged by the law of armed conflict. A civilian who participates in hostilities does not get that immunity and can therefore be punished under ordinary civilian law for any act of violence that they commit. And so if a CIA operator or a CIA contractor flies a drone and conducts a strike, they are committing a murder under the law of the territory where they conduct that strike. Now, does that violate U.S. domestic law? That's very arguable. I think John will certainly say that it does not. Should the United States government be in the position of putting its employees in a situation where they are murderers and are subject to capital prosecution in other countries? I don't think so. Now, the complicating factor to me is what's going on in Guantanamo, which I've spent a lot of time, because most of my scholarship focuses on the military commissions. In Guantanamo, however, the United States is effectively taking the opposite position and asserting that our detainees there have committed war crimes by participating in hostilities without being privileged belligerents. And I don't think the United States government can properly put itself in the position where, on the one hand, we are paying civilian employees to engage in acts of violence in an armed conflict at Langley, And yet at Guantanamo, we are prosecuting our adversaries for doing exactly the same thing. So the hypocrisy of the US approach I find very troubling, and I think that it's undermining our credibility around the rest of the world.
Dave, for those that are keeping score, you've anticipated that Bill is going to disagree with you. We're going to let Bill answer.
I'm sorry. I don't mean to put words in his mouth.
Hina, in her comments, as I listen to them, suggested that she may not completely agree with this view, but I'm going to let Hina speak for herself on this important point. And I want to remind you of the scenarios that we have Zawahiri, good intelligence, and the triggering mechanism is a sort of laptop Apple that Ben Wittes has. I mean, this is also secret. And we want to know, does it make a difference whether it's the CIA pushing the button, and you push the Apple. Don't do that, Ben, please. Air Force or a contractor? Bill.
I think Dave makes a very persuasive case, and I think he raises a number of troubling issues that deserve discussion. And I think in part he's foreshadowing what I hope we'll talk about later is what should we do. There are serious problems here. I think the most facile answer to Dave is that U.S. law would permit this to go forward. It's facile because it doesn't respond to Dave at all, but let me just remind you the stuff that I said in the opening, and in addition to that, under the supremacy clause of our Constitution, the U.S. law last in time, statutes and executive orders and the like that post-date the Hague Conventions may allow us to go forward on the basis of our own constitutional law. I think, though, back to the global picture, and wherever Zawahiri is, one of the things that's going on as we speak is that the customary law that Dave referred to is being made. It's being made by state practice. And it's confronting these difficulties that Dave alludes to, and it's exposing them, but it's also changing the way we do things by allowing actors that are not wearing conventional uniforms and following a chain of command to engage in these activities. And one other thing, customary international law also has a doctrine of self-defense which evolves. And that evolving doctrine may come to recognize customarily over time the legitimacy of non-military actors pushing them's energy.
Hina, before you answer, you've anticipated that I disagree, and I disagree, but I want to throw one bit of information. CIA officers break the law around the world in almost every country of the General Assembly every day, and it's called committing espionage. And it is authorized by our Constitution, the National Security Act of 1947, and we recognize that they are subjecting themselves to prosecution in those countries. So I don't think it's such a stretch for us to then infer, well, if we're breaking the law and subjecting our officers to the laws of Pakistan, Yemen for espionage, then we will accept that they're tough enough to tolerate the risk of being prosecuted, whatever the risk is, for a more serious crime, murder, than espionage. But in some of these countries, the penalties are much the same for murder and espionage. Hina. Now the moderator has stepped out of his role and became a panelist, but it's difficult now. No,
So
push me back.
yet another
Panelists.
instance of the revolving door problem. I agree with Dave that under IHL, civilians, including intelligence agents, are not prohibited from participating in hostilities, and rather the consequence of participation is twofold. Because they're conducting targeted killing, including prosecution under the domestic law, which is consequence number one, intelligence personnel may themselves be targeted and killed. Going back to consequence number one, intelligence personnel don't have immunity from prosecution under domestic law, and I think that the risk is heightened and temperatures raised when you're talking about the conduct of killing in the territory of another state as opposed to espionage, although I think the Davis case in Pakistan shows the extent to which espionage issues can themselves raise significant policy and political considerations. One thing I would throw out there in addition to sort of agreeing with Dave on this is, again, in the context of direct participation in hostilities and consequences for the CIA. One of the things that the US has done in the military commission's context is to criminalize material support. And an aspect that I think both the academy and practitioners have understudied, both as a theoretical matter as well as a practical matter, is the extent to which the concepts of material support, that criminal law flexible concept, is mapping onto and influencing the concept of direct participation in hostilities. Now, we know, because our criminal laws and the Military Commissions Act are public, what the definition of material support is. What we do not know, and no country has really disclosed, is what the definition is of direct participation in hostilities that may subject both civilian, including alleged terrorists, to killing, as well as Dave and Bill raised the possibility that the same analysis may be applied back to our own CIA and military contractors. I'm not sure that I want to get into a whole discussion of direct participation in hostilities. It took the ICRC 5 years to discuss these issues, and we certainly don't have that much time. But I think that when we're talking about who can be targeted and under what circumstances, one of the things that needs to be made transparent, and going back to the first issue that I put out there for you, is what is the kind of conduct for which someone can be subjected to killing? We talked yesterday in the context of the panel on detention about the issues raised by membership. I think you need more than membership. I think that the ICRC's guidance indicates that. The issue, though, is what more than membership is needed. What are indicia of membership and what more than membership is needed. And we simply don't have an answer to that, and I think we need to get.
Hina is anticipating, she's answering 2 questions at a time, so I'm very happy with Hina. So she's giving us her view on the question of does it make a difference. You've heard her answer, and then she's marked for you the importance of this debate, this category of directly participating in hostilities, and it is, even with the ICRC guidance, it continues to be a very hot debate, and that in effect is giving guidance on the first question that I proposed of who can be targeted. So the moderator is proud that we've got answers to 3 of the questions. I'd like to throw another question out, and this is a challenge to the importance of law in this area, that whether we pick human rights as the paradigm, IHL, international humanitarian law as the paradigm, or self-defense, don't you all agree that at the practical level, in advising the operators on who can be killed and who cannot, that there is a convergence, that we should be talking more about levels of certainty, the intelligence that goes into it, and I recognize we're asking to peel back from the classified realm, but does that initial category, the choice of paradigm, to use Dave's term, does it really matter? Bill?
I think you allude to convergence, and I agree with you that it's going on, and I think it's a good thing. I think that operationally, those who are in the field are making operational law as well as operational policy and making tactical decisions that have operational effect. And from what we can see in the public domain, from the lawyers in the field, you learn by reading the papers they write and the manuals that are available for public view that the criteria that are being used to conduct counterinsurgency, for example, stepping away from targeted killing for a moment, go beyond the law. They provide protections for individuals and constraints on operators' discretion that aren't part of IHL or human rights law or U.S. law.
An additional level of comfort and caution.
Additional level of caution, I would say.
Dave?
I think it does matter very much. And the reason I say this is that, a few moments ago I spoke about who I thought was legally entitled to participate in hostilities. Well, the flip side of being legally entitled to participate in hostilities, what you give up in exchange for gaining the combatant's privilege, the immunity from the domestic law, is you in turn are subject to being killed at any time or any place during the duration of the hostilities, simply based on your identification as a combatant. Now,
Dave, I'll jump in there. I agree with you on a legal point, but let's imagine you're a CIA drone operator, and the media says they're in Langley. Do we really think Al-Qaeda is going to be able to get that person? And if we have Al-Qaeda members in the United States, won't they try to kill a big group of us rather than going after a couple of operators that might have been former Air Force that are on loan? So it's a legal point, but does it matter at the operational level?
well, it matters if we take the law seriously. I mean, if we want to, follow the law, then by identifying someone as being the functional equivalent of a combatant or a commander who has command authority over combatants, then there is essentially much greater authority to target them at any time or place. Now, if we're saying we're outside the law of armed conflict paradigm, and we're not going to constrain our targeting to people who we are essentially identifying or equivalating with combatants or civilians directly participating in hostilities engaged in a continuous combatant function, then we are in a realm of self-defense, which requires, as a matter of international law, a high degree of imminency, right? We don't allow police, the difference between a soldier is the soldier sees someone who they recognize as an enemy, they shoot first. A police officer sees someone identified as a suspected criminal, they must call upon that person to surrender and can only use deadly force if that individual is posing an imminent, immediate threat to that police officer or to other civilians in the immediate vicinity. And so if we are going to justify targeting outside of the armed conflict paradigm, then the problem with these attacks is that it's virtually impossible to demonstrate the imminency threshold that's required under international law. And therefore, I think that the armed conflict paradigm is much more useful to us as a nation if we are concerned about compliance with the rule of law. Now, if we're not concerned, right, if the idea is that, well, we do espionage, we don't care about law when we're exercising national security authority outside the country, then it doesn't matter, right? We can just decide who we want to target, and we can give the folks pulling the trigger on the drone whatever authority we want to. So, this argument is premised upon the fact that you accept that it is in our national interest to follow international law, even if other parties lack the ability to compel us to.
I see Bill shaking his head, so I'll let Bill jump in and then Hina, pending a response to
Well,
the
just
question.
briefly, I mean, there is another version of the criteria for self-defense that evolved from Abe Sofair more than 20 years ago now, and more recently by the Legal Advisor's Office, that in the wake of a continuing course of terrorist attacks, we can act to prevent and deter future attacks. Notice I didn't say imminence. And that standard, of course, is vague and has to be operationalized, and it's operationalized in concrete ways that, for the most part, we can't know. But I think it's not the same standard as the one that evolved in that tradition.
And those taking note, even if we justify the use by self-defense, then we will have other debates. We could have a panel here on, well, what is self-defense? What is the trigger for self-defense? You're getting a sense of it there. Dave, I want to be more precise on my challenge. Even if we accept we're an IHL and that by our allowing CIA people, they then become subject to attacks from Al-Qaeda. If I understand that's your analysis, let's say I accept that. Would the Office of Security then, at CIA headquarters, would they need to have more security for the drone operator than they do for the people in the clandestine service? Are you saying that this legal effect subjects them to greater risk of attack? Because CIA officers live with risk.
Well, one of the problems, of course, then is what is the command structure within the CIA? Are we saying that there is an office that is responsible for flying drones and that we are going to designate that particular office and only those individuals as participants in this armed conflict? Or are we saying that the CIA now becomes a sixth military service after the Coast Guard, and therefore any employee of the CIA who has an operational role is the functional equivalent of combatant to be targeted? That's one of the great complexities. Within the military, we know that there are only two categories. Basically, everybody who gets issued that green ID card is treated as a combatant, whether they are in fact are an infantry soldier or an aircraft mechanic or a truck driver, unless they are a religious person or in a medical duty, and those folks carry a separate pink ID card in addition to their green ID card. If you only carry the green ID card, you are a combatant. You are entitled to use a weapon. At the same time, you're a valid target. In the CIA structure, how are we structuring the CIA? You know, that's the key issue. Uniforms would help, but you know, a few years ago there was a guy outside Langley with an AK-47 shooting CIA people, and you know, we thought he was an ordinary terrorist, and he was captured overseas and brought back and put on trial as a common criminal.
Brought back by rendition.
If the CIA is going to participate in hostilities, then if that guy were to put on an Al-Qaeda uniform and shoot the same CIA people in line, maybe that now becomes a perfectly legal act, and all we can do is detain him for the duration of hostilities as a prisoner of war. I mean, that's a real problem with CIA participation.
You know, so convergence and then David's point here, either or both.
Well, I mean, let me address my agreement, or let me express my agreement with David's point as coming down to, you know, while I may think that the military needs to disclose more about its targeted killing practices, the reality is, and I've sort of thought of it this way, that in talking to military officials and studying this country's history, the Geneva Conventions are part of the DNA of our armed forces in a way that the Geneva Conventions and the laws of war, assuming that they're the ones that apply, are not part of the DNA of the CIA. So there is significant concern about what rules the CIA operates under, including under the context of armed conflict, and to the extent that they're operating with the armed forces in targeted drone killings, are they following the rules that the military uses? And if not, are there different standards that are governing? And what complexities and problems does that give rise to? We simply don't know the answer to that. I also think that it is in our national interest to follow laws. And so I think that the convergence raises a number of issues. One, it ignores the fact that self-defense and armed conflict and law enforcement paradigms all have different tests for the ability to conduct killing. It ignores the fact that self-defense under international law is applicable to the use of interstate force. So the responsibility for violations of the doctrine or the state's right to self-defense rests with the state. It does not rest with individual actors who may then carry responsibility for violations of the law applicable to that specific use of force once we go through the analysis of whether the self-defense response was legal or not. And let me just be a little bit more concrete about that. So, for example, in self-defense, when we talk about necessity in international law, necessity refers to whether or not the means that the state is taking are necessary to defend itself, to act defensively. When we talk about necessity in the context of armed conflict, of course, we're talking about whether the act is necessary in order to achieve military goals. And convergence, I think, I'm sympathetic to. We need to be able to boil rules down to what what operators on the ground will be able to follow easily. I understand that. But I think going to convergence too quickly before understanding the different legal regimes that apply and the different consequences, both in terms of state responsibility and individual responsibility, does disservice both to our national interests and to the individuals we might be seeking who are carrying out these processes.
We're going to save time for questions from you all, but I want to get through our list. And here we're going to imagine that our audience, it's Barack Obama out there. Every one of these people is Barack, and he's a very busy man. So he's got some short questions, and because he's the commander, he's only going to give you 1 minute of his time because he's racing off to another meeting. He's going to be doing an off-the-record interview with Ben Wittes for his blog by the name of Lawfare. A different discussion there. That's a free promo for you.
First I get blown up, and then...
Blown up, now you're going to get to talk to the president. So I've rephrased the question. Can a secret invitation from a foreign state to use force in their territory, can that be valid, whether it's for self-defense or inviting into an armed conflict? And I guess you can look at Paul. Ben doesn't want to be Obama, so look at Paul over there and just look into his eyes and say, Mr. President, here's my answer.
The question? Can a secret evidence?
If the invitation of force from a foreign state, Pakistan, Yemen, is secret, does that undercut the validity for purposes of international law? Because one of our colleagues, and we don't refer to our colleagues when we're disparaging, says, well, the authorization invitation has to be public, so that a private wink-wink authorization from Pakistan is invalid. That view has been put out. Do you agree or disagree?
Well, let me answer it this way. What we're talking about is whether states can consent to other states using lethal force in their territory. And the answer is yes, but only to the extent to which the inviting state's consent applies to situations in which, if the state were to carry out that act, it would be legal. So what am I saying? I'm saying that Pakistan could consent to the United States conducting targeted killings in Pakistani territory, but only to the extent that Pakistan could itself kill the individuals at issue. And I would go a little bit further, which is to say that Pakistan should ask the United States to justify the basis for the killing, and should also look to whether killings on its own territory were carried out in accordance with the justification itself.
But you're getting to the substance of avoid the question. Can they keep it a secret? Can they pretend for the world that we have not authorized the United States to come in? And assuming they meet these other requirements, is secrecy a problem for the validity of this invitation to use force in their territory?
Well, I think, to the extent I understand what you're getting at, I think that in order to, the conformity with the rule of law requires a degree of transparency about what you have said is permissible or not. I think that carrying out killings in secret, yes, it raises significant problems under both international law and probably domestic law.
Bill? On that?
WikiLeaks may make this question moot. But if it doesn't, I think the answer is yes.
Remember, Wiki is State Department stuff. The CIA has done better at protecting its communications.
Well, so far. And
Paul's trying to break into the computer right now.
I think it could be secret based on the necessities of real-world politics and diplomacy. I think it's important that assurances eventually come to light, that they may be historic, that consent was given, and that our officials act on the basis of that consent where it's required. I agree with Hina that consent doesn't forgive unlawful actions, and I would also assert that consent is not always required.
I agree with Bill that I think the consent can be secret. I agree with Hina that the authority of a foreign country to authorize targeting on its territory is limited to the authority that foreign country would have. But I think there's a third requirement, Mr. President, that we haven't addressed, and that is that it's also limited to the authority the President has to use military force. One of the undiscussed issues with our targeted killing in Pakistan is that the government of Pakistan is feeding us intelligence leading us to kill members of the Pakistani Taliban. They are not part of the authorization under the use of military force, and so I don't think the President has constitutional authority at this point to kill people who he has not been authorized to engage in conflict with by Congress.
Any response to that? Or?
Well, I think Dave makes an important point. I think, in fact, I don't recall the designations now, but at least 4 discrete groups that might be a menace on cross-border activities, and so I agree with your basic point that we wouldn't have, on the basis of the Constitution or the AUMF, the authority to go after Pakistan's enemies. Yet some of those same enemies are inflicting harm at us across the border into Pakistan, so we can repel those attacks if they're undertaken by Pakistani Taliban.
I would agree with both points and sort of raise the issue also of, this goes to the issue of whether drone attacks in the Pakistani-Afghan border areas are legal, highly contested, and just talking about that a little bit more directly. I think that difficult question, but certainly, you know, I think that there would be justification for the proposition that to the extent people in the Afghan-Pakistan border are engaging in hostilities directed at the war in Afghanistan, that they are then justifiable targets. But then as you go further and further away from that linkage to an ongoing existing armed conflict, I think the more questionable it becomes, and you begin to reach the outer regions of AUMF authority and constitutional authority.
We could put a face on this. I have some notes about the Tula Masood. This was the strike in August of 2009. He was the head of the Pakistan Taliban. He terrorized the Pakistani government for years. He sent an army of suicide bombers into the streets in Pakistan. He probably masterminded the assassination of former Prime Minister Bhutto in 2007. He was implicated on attacks on the U.S. military in Afghanistan. In August of 2009, 2 Hellfire missiles shot from a Predator drone, probably piloted by someone at Langley, hit his father-in-law's house where Masood was on the roof. He was a diabetic. He may have been receiving intravenous treatment, or he may have simply been resting with his wife and some family members, and the strike killed Masood, killed his family, his uncle, and I don't know, 8 or 10 others in the vicinity. Was it a strike that was at a combatant? Was it unlawful execution?
Very, very important issues. And one of the policy issues is, even if we accept that this is valid as a counterterrorism tool, then many people have put forward the idea that it may be ineffective in our counterinsurgency strategy. So we're now creating more images. You remember Balawi, he was the Jordanian double agent that killed 7 people in our CIA base in Khost. If you go, and it's on YouTube, and you get the full video, and listen to his martyrdom video, he in large part says that this was payback for the drone strikes. So it has a ground level action, reaction, and we're also talking about the effect that it has in recruitment. We have opportunities, academics and policy people of this quality, to brief policymakers. And I know on the issue of whether we should be doing trials of suspected terrorists in the civilian courts, that Anthony Romero, Hina's colleague at the ACLU, had some time with the president. And he was very pure in his recommendation, and he looked the president in the eye and said, I believe every one of these terrorism cases must be done in civilian court. Obama disagreed with him. We've had the announcement about KSM. So I'm going to give each one of our panelists, and I thank them for their analysis, and we'll have questions from you, but this is your Obama moment. He's doing a review of the drone policies. He's particularly concerned about the CIA policies, and you're going to have 2 minutes. 2 minutes to wrap up your ideas. He's a knowledgeable person. He's a constitutional law professor. What do you want him to do differently about the drone program? Dave.
Well, first, of course, I want the drone program entirely in the hands of the military, and I want it conducted in accordance with the law of armed conflict. So that means limiting the targets and ensuring that we're applying strict rules of discrimination and protecting innocent lives. Now, I think the reality is that in the past year and a half or 2 years, that the CIA has in fact become much, much more careful. And so generally the credible accounts of civilian casualties are very, very limited today, whereas 3-4 years ago, there were large numbers of civilians compared to the number of deliberate targets. But I think recognizing the potential political backlash, we ought to really reserve this for very key high-level leaders whose replacement is difficult. There's some evidence now that we're actually just sort of identifying people as low-level fighters and striking them deep in Pakistan, and that probably doesn't give us sufficient bang for the buck in terms of the uproar that it causes. In fact, the New York Times, the Times Square bomber also said in interrogation that one of the things that motivated him to try to blow up Times Square was the drone program in Pakistan. So it is definitely having a detrimental impact and being used by our adversaries for recruitment. So I think that we need to put it on strict legal grounds, articulate those grounds to the world population in general in order to try to get support for it and limit it to actual high-value targets.
Bill.
I would say 3 things to the President. First of all, I'd try to emphasize the importance of constant monitoring and evaluation of the program. find out always, every day, what's going on the ground and do your best to tailor the program to the extent it's going to be used so that it's effective and doesn't have these counter effects that both John and David alluded to. Second, I would congratulate the President on beginning a process of embracing international law as part of the law of the United States. And I would encourage him through the Legal Advisor's Office and everywhere else in the government to continue to integrate international law with domestic law, not just IHL, but the broader principles of international law, which for too long had been on the sideline. And third, I would warn the President, I would urge him and caution him to pay attention to the possibilities of regulating drone use in a separate international instrument worldwide, because now everyone and her sister has a drone. It's relatively unregulated. We do far better at regulating their use than anybody else in the world. And there's a danger that this technology will go completely zany and cause havoc in places around the world that we're only beginning to think about now. So I think international regulation would be highly desirable.
The Iranians have drones. It's been reported that Hezbollah has drones on Bill's point. Hina, Mr. President?
I would start by also complimenting the President, because apparently that's one of the better ways of getting the next critical points to be heard, and say that it's true, it works with supervisors as well.
And spouses and friends and...
Human nature, which is to say that, you know, the administration has taken some important first steps towards transparency, including through Harold Koh's speech at the American Society of International Law about what standards govern. I would then, though, remind the President that at this point the executive branch has been successful in asserting the unilateral authority to determine when to use lethal force, including outside of what we see as the context of armed conflict, to determine what the extents of constitutional rights of citizens against whom that lethal force can be used might be, to determine whether force in fact has been used unlawfully, and whether the executive branch has complied with the limitations to the extent that it has set them. And so I would say and urge to the President that he make public the legal justification and standards for targeted killings that take place, including what legal frameworks apply, what the criteria are for who can be targeted, what safeguards are in place against mistakes being made. We've seen recent reports, tragic recent reports of intelligence failures, so what safeguards are there in place to guard against them? And what accountability measures there are in place to ensure that when things go wrong, that we're able to stand up and say, we're doing what we have to. And the reason for all of that is not just because it's lawful and it's important for us to comply with the law, but also because mistakes are going to be made in the use of this technology. And in response to, you've made a mistake, the blowback that might occur, the best thing a state can do is say, yes, but we've got standards and we're going back and we're going to make sure that they were complied with, and we're going to provide accountability and continue to be able to uphold both values in terms of strategy, but also values in terms of tactics.
Audience, look at your scorecards. I think we have to congratulate our panelists. You've had thoughtful answers on 6 of the 7 questions that we started out with at the beginning. The only one that we haven't dug into is the idea of armed drones on the Mexican border. Now, that was intentionally provocative on my part. I hold it in reserve just in case you all stare at me without questions. We can go to that question, but I sense there are many questions for the audience. So I thank our panelists for these thoughtful answers and their analyses. And do I decide, or? Well, my friend Steve Dicus is here, so I must recognize Steve, also co-editor of the National Security Casebook with Bill Betts.
I have a question about a space-time continuum. If we can assume, maybe we can, that Article 51 allows states to pursue non-state threats wherever they can be found, I wonder if there are any geographical limits on that ability. if an identified al-Qaeda operative travels from Peshawar to Paris, can we use a drone to take him out on the Shamsi? Regarding domestic authority, if our target travels from Peshawar to Pittsburgh, can we go after him there? Regarding time, I wonder if how long the authority on Article 51 lasts, if it exists at all. If Bill has referred to a continuing threat from al-Qaeda, but isn't there some point at which the until provision in Article 51 requires the participation of the Security Council in authorizing the use of force? And second, on the domestic front, if authority comes from the AUMF, how long does that last? Does it last forever? And who is entitled to say when that authority stops?
So I heard 4 questions there. So one is our Peshawar to Paris, can we whack him in Paris? One is Peshawar to Pittsburgh, can we whack him in Pittsburgh? Then do we need to go to the Security Council under Article 51 at some point? And then how long does the authorization and use of military force go? People like Jack Goldsmith are saying we need to update. So there are 4 there. You don't necessarily have to answer all 4. Maybe Steve wants you to, but at least answer a few of them. Dave, you want to go first?
Okay. Well, again, this is one of those areas where I think my insistence on the armed conflict paradigm is really helpful, because I think the answers are relatively straightforward. Now, an armed conflict traditionally takes place in the territory of the conflict parties and on the high seas. Now, when we're talking about other countries like Pakistan, Yemen, France, then we get into essentially rules of neutrality. There's a limited authority to strike if those countries are unwilling or unable to honor their duties as neutrals. So with respect to Paris, the answer is no. We can't conduct a strike against a guy in Paris unless we contact the French, identify that there is an ongoing violation of their neutrality, and they would then refuse to take any action such as arresting the individual or interning them for the duration of hostilities. With respect to Pittsburgh, this is mind-boggling, but there's no legal problem whatsoever with using military force against a terrorist in Pittsburgh, because that is the territory of a conflict party. You know, we're spoiled in the United States because all our recent wars have taken place overseas, but we forget most countries have to fight their wars in their own territory, and we have the same legal right to fight our war on our territory as any other country does. How long does the AUMF last? Well, there are several Supreme Court decisions that hold that it is entirely up to the political branches to decide how long an armed conflict persists. So it's not up to the courts, will not decide that. And so as long as the president is willing to say that we're still in this continuing conflict and Congress does not vote to override that decision, then I think as a matter of US law, we are in an armed conflict. With respect to the Security Council, I think one could argue that we consulted with the Security Council after 9/11. We got the 2 UN resolutions that refer to the attacks as being an armed attack. And so I think until such time as the Security Council would vote to compel us to cease and desist, which it obviously won't be able to do with us having the veto, then Article 51 is not implicated.
4 questions, 4 answers. Hina, do you want, or Hina, Bill, or we can go back?
Yeah, just a couple of points there. I think that self-defense would not apply in the case of Paris because for the same reasons that Dave laid out there. But what I wanted to focus on was Pittsburgh. While as a theoretical matter, yes, it is true that this is in the territory of one state. You know, the principle of military necessity comes into play when you're talking about, assuming that you're talking about an armed conflict paradigm applying with respect to this person. And what's interesting about that is that, you know, I think one of the areas that is underexplored when people say, well, an armed conflict paradigm is better because it allows us more flexibility, is that people forget necessity in that analysis. And necessity, I think, brings the issue into point that is it militarily necessary to achieve the military objective in order to conduct this targeted killing? And I think under a necessity analysis, you would have to look to alternative means of capture or restraint. And so I don't think, and I think that you would find them. Yes, I would largely agree that it is up to the political branches to determine when a conflict ends. But with respect to judicial review of conduct carried out in the context of armed conflict, certainly I think we have indications from the Supreme Court, at least to the extent it's spoken on these cases, that to the extent that the conflict continues for a longer period, to the extent that conduct is less core to what happens on a hot battlefield, that the likelihood of judicial review of this conduct is likely to go up.
There's another reason that the answer is no. In Pittsburgh, that's the Fifth Amendment. I like the alliteration in your choice of targets, by the way. And I agree that the AUMF is stale, and I think it would be worth having a broad conversation about revisiting that resolution, not just with respect to questions about targeting, but several of the others that have come up here during this conference.
So I saw the hands and I recognized where to, here I saw the gentleman, then to Ben, and please.
Okay.
And Steve's question was a very good question, and it had 4 parts, but now if we could have 1-part questions and then...
May I address the president, please?
Please.
Well, sir, I am not a lawyer, and I certainly can't speak to the legality of using drones, but in a panel earlier today, I learned that one of the purposes of terrorism is to goad its target into overreacting. That reminded me of an ad I saw in early 2003 in the New York Times. It showed Osama bin Laden in the pose of Uncle Sam, you know, where he says, "I want you," the First World War poster. And he was saying, "I want you to invade Iraq." And the image I would like to leave you with is Osama bin Laden today saying, "I want you to fire drones at people in Pakistan and Yemen."
Reaction?
Fair point.
Fair point. So, sir, I see your hand in the back, and then we'll keep, and Ben, you're after that. Please.
Okay, so you're watching news tonight. Breaking news. It appears that Anwar al-Awlaki has been killed in an apparent drone attack in eastern Yemen early this morning in Pakistan. What is your first reaction as a human? And secondly, what is your first question, or first 2 questions you'd like to know as an attorney?
As an attorney. So your human reaction, then your legal reaction. And I think implicit in the question is that being a lawyer means we have to leave some of our humanity behind.
Make no sense.
Well, I'd want to know who else was harmed. Were there other casualties? I certainly wouldn't bemoan his passing. And as a lawyer, of course, I'd want to review how the decision was made and get as much information as I could about the linkage of him to the crimes that he's accused of and to the intelligence that identified his location. I want to verify that it was indeed him that was targeted and killed.
I want to know more about the operational allegations because it's interesting. Every press account you read or discussion of him refers to him as a Muslim cleric, but never discusses the fact that the role of a cleric is protected under international humanitarian law. So lately, the government has been responding to that by throwing out terms of operational involvement. So I'd want to know what evidence we had of operational involvement, and I'd want to know whether or not there was any possibility of capturing him, or the government of Yemen could have apprehended him, or if we just killed him for convenience. And I have to say on this that having studied the law on this, so much that my emotional reaction will really depend on whether or not this was done lawfully or not.
I would agree that I would want to know what the criteria were that were used to determine the legality of this killing, and the civilian casualties that also, if any, that accompanied it.
And I just imagine how Panetta would take the news to Obama, but it's Ben's question.
So since John has already blown me up once in this conversation and scheduled an interview with the president, I figure the least I can do is ask a question.
And we have a drone up right now, a micro drone.
So I understand historically how the drone program ended up in the CIA, which has much more to do with where the technology developed and where the capacity developed than with any specific consideration of where the appropriate place to house the program is. I'm interested in the panel's views on the subject of whether there's any strong prudential reason, leaving aside the legal questions or informed by all the legal concerns that you've articulated, whether there's any strong prudential reason for it to remain there, or whether there is, or any operational reason, or whether it simply is a artifact of the historical and bureaucratic development of the program, and it really ought to be migrated to the military at this point entirely.
But I'm going to take the moderator's prerogative. I'll answer it and then see whether the panelists agree.
Fair enough.
So to the extent that we have countries that want these activities, but they want it kept secret, they want the deniability, then it becomes a covert action, then the CIA is involved. To the extent that the CIA makes the argument that we need to work with liaison services and human sources, and we're better at this, and we want to have a direct connection to the Pakistani liaison service, that's an argument for it to continue. Now, the counter would be that we want them to provide the information to CIA and give it to another entity. That would be a check. But they're going to say, well, we understand the languages, they trust us, we're going to be able to check and verify their information in a way that the military can't. And I think that you had said prudential. I think there's a very practical reason. This program gets a lot of attention, and from a bureaucratic perspective, you're not going to give it up at the CIA because it has the president's attention. It's high profile.
Well, that's an excellent. That's an excellent bureaucratic turf reason to believe that it won't migrate, but it's the worst conceivable reason not to migrate.
Agreed.
Right?
Panelists.
As a practical matter, the CIA, for decades we know, has engaged in covert operations, which means illegal, at least illegal in the places where they're being conducted. So perhaps, this operation was, could argue, given to the CIA because it, like espionage, is a violation of the local law, and the Air Force doesn't do violations of local law. So that's certainly a possibility. But if it's justified under the law of armed conflict, I don't see any reason why the military can't do it and yet keep it secret. The military does all kinds of operations that we don't admit to, around the world. Think of the nuclear submarine program for years during the Cold War, for example. So I don't think just because it's secret, it needs to be in the CIA. And I see no reason. One of the great things about drones is the ability to import intelligence information in a way. Think of a manned aircraft. Two guys strapped into pressure suits, strapped to ejection seats in an incredibly uncomfortable and hostile environment for hours at a time. Drones, you have people sitting in comfortable chairs in an air-conditioned space. They can get up and they can go to the bathroom. They can have meal breaks. And there's no reason why you can't have a CIA guy in the trailer with them with direct intelligence links getting them the same information. It doesn't require a military person to provide intelligence. That's not necessarily a military function. So you could easily merge the best advantages of both, I think, into a legally superior program.
I agree with that, and I think cooperation, getting the best of the assets involved in trying to do things well makes sense. As you know, then one of the looming shadows here is congressional oversight. So which committees are you dealing with? And it's very difficult to move things from one place to another without at least the acquiescence of the overseers, and also the leadership in the executive departments. During the Rumsfeld era, he wanted everything, and he wasn't going to let anybody else do anything, and things are different now, and I think the style and proclivities of leadership on both sides of military and intelligence matter a great deal.
I think that the others on the panel have a lot more expertise than I do in operational issues, so I'm not going to go there, but I actually have a question in response to your assertion about deniability. And deniability may certainly be a valid reason offered up to why CIA might get involved in that secret. But What does the revelation by WikiLeaks of that cable in which the president of Yemen says, I know that will accept responsibility, and I'll say that yes, I was the one who conducted the killing, authorized the targeted killing, and its consequences. What does that say about deniability in a world where it's harder and harder to keep secrets, especially secrets about weapons firing at people from the sky?
I think it's difficult to appreciate the importance of that thin veneer that we will not have official confirmations. It's important in developing relationships with human sources, with liaison services. How many of you think that we have CIA activities in Russia today? How many of you? Now, I, as a former CIA employee, can neither confirm nor deny. Why? Now, why do we, if your assumption is correct, why do we need that thin veneer? Because then we don't have an official acknowledgement, and then we don't put the host country in a position where they have more pressure. Because that little bit of deniability may be the difference between continuing operations or not. That this is why we have a publication review board, and it's very difficult, I think, for people that haven't been there to appreciate. You may all assume something, 99.9%, and we're not, but there is a difference. There's that little bit of uncertainty, and if an official or a former official confirms it, now we've eliminated that little bit of deniability. And sometimes that's all the difference in the world. Sir?
Yes, bracketing the combatant's privilege issue with the CIA or civilian contractors, again, assuming any of this is transpiring, is there anything different from a law of armed conflict perspective about the analysis by virtue of the technology? In other words, drone technology versus an F-18 with a precision-guided munition or a Special Forces assault unit. I mean, it seems like all the issues that we've talked about, it would be the same. Is there anything specific about drones that implicates, law of armed conflict concerns?
No, I don't think so. A lot of commentary has been written, and certainly among the Pakistani public, apparently, they refer to this as a cowardly way of war. But as I look at the whole history of warfare and weapons development, it's all a series of progressions of steps taken to try to render one's own side relatively immune from attack while striking effectively at the other side. So first, in a day in which we fought wars with essentially swords and maces, the idea of the crossbow was your soldiers could now be at a distance at which they were invulnerable to the weapons of the other. The submarine, the torpedo, the cruise missile, these are all perfectly lawful weapons which render the fighters virtually immune from counterattack. So as a matter of law, the law of war requires legal equality between the combatants and requires legally that the fighters on both sides be equally liable to counterattack, but it doesn't require any practical ability. And so the fact that we have guys in uniform at Creech Air Force Base in Nevada flying drones over Afghanistan, where as a practical matter, they're pretty much physically immune from attack, doesn't change the equation. And that's really the one thing I think that's been argued from the law of war perspective as troubling some people. But I see as a matter of law that's not an issue. Otherwise, the drone is, it's just firing the same Hellfire missiles as tanks and helicopters are firing. So the weapons themselves, the means of conducting the attack, are perfectly lawful as long as the folks that are operating them are legally subject to attack in turn. I think there's no legal issues.
Dave, I hope that I'll please Hina and maybe you, because I've listened to your arguments. I have a piece coming out right now. It's applying IHL on this question. And I put forward the idea with a co-author that the standard that we hold a drone operator to is much higher than the standard that would apply to a Marine on the ground. So the drone operator, even firing in Afghanistan for 3 reasons. So I'm agreeing, I think we can go further. The drone operator is not at risk. So when we're doing distinction, the Marine on the ground says, is that a combatant or not? If he gets it wrong and assumes civilian, it turns out to be a combatant, he gets a bullet in the head. Your point, the drone operator is not at that risk. The drone operator is not stressed, is not fatigued the way a Marine on the ground is. And the drone operator has far better intelligence. Yes, the Marine has our multi-platform collecting, but the intelligence, as you all have stated, is much better for the drone operator. And I think a reasonable application of the rules of IHL, including proportionality, necessity, and feasible precautions, say as a matter of law that we have to be more certain in pulling a trigger on a drone, whoever is pulling it, than the Marine on the ground at the same target.
Yeah, I mean, my sense is that the legal rules are the same, but that the law of war adopts a reasonable combatant standard. And
Based
so,
on the facts.
And so, based on the facts. And so under exactly as you described, the facts of the drone operator are sufficiently different that the practical outcome of the application of those rules does hold the drone operator to what appears to be a higher standard, but it's simply the application of the differing facts to the same rules and the same reasonable combatant standard, essentially.
Bill or Hina on this?
No, I think that's right on, very useful.
Right, so let's saw a question right here, and then in the back, and I think that'll be, this question and the last, we might have time for one more. Thanks.
Well, we don't have an ethicist on board here, but could you nevertheless pretend to be an ethicist and address, from an ethical standpoint, the sitting on couch at home and pushing buttons, dropping bombs on a territory somewhere else where you're not present?
Ethical implications of drone strikes. Anyone?
Is it really different from the cruise missile attacks, where folks are on a ship 500 miles offshore, or it's perhaps it seems different when if you've seen like some of the news broadcasts that have actually followed the drone operators. It's weird to see an individual in a flight suit sitting at breakfast with their kids. They get in the car, they drive to the Air Force Base, they fly the drone all day, they get back in the same car, they drive in their flight suit to their kid's soccer game, they watch the kid play soccer, and then they go home and have dinner with the family and say, well, how was your day? Well, I got to be on my math test today, Dad. I'm sorry. Oh, well, I killed 37 people in Afghanistan. It's weird, but I'm not sure that it is really any different, than as an ethical matter than someone being closer to the scene.
So we're going to take the last question there. I thank our panelists very much. I thank you for your attention. So this will be the last question. We'll have our answers, and then we're going to go promptly to lunch. Thanks again to Scott Silliman for inviting all of us.
Thank you. I'm going to take on two personas very quickly and make two comments and ask for reaction. In the first place, I am the mayor of Pittsburgh. Mr. President, call me, and I'm going to take on my own persona as a professional soldier, and I think we need to be very careful about our terminology. If we've got a contractor who is using Ben Wittes' laptop to deliver those munitions, we need to call him a mercenary and treat him in that way. Thank you.
Contractors are a whole another kettle of fish, as they say, and it would take another 2 hours, I suppose, to explore the law. There are different legal bases that we would have to touch to talk about the authority of the contractors. Some interesting work that's going on right now, I think, that may be pertinent, responsive, is that working on the terms of the contracts themselves to better provide accountability mechanisms and control over the contract personnel. Regulations in DOD, Department of State, Department of Interior have been ramped up in the last 4 years, but they leave a lot to be desired. There are ways that contract abuse can be prosecuted. The courts of the United States, civil suits may be brought against abusive contractors in the United States, but they're not very effective to date in doing any of those things. So I think working on the contract relationship may be responsible.
For another panel, I have a standard joke in these situations. My mother and father are both from Iran. They came to the United States in 1962. I was born here. That's why I could work in the government. But I'm mindful that my people, the Iranian people, have a bad reputation about holding people against their will or holding them over time. 1979 to 1981.
Is this an invitation for me to break into your panel?
This is an invitation.
Well, join me in thanking John and the panel.